Oyez, oyez, oyez. Anyone having business before the King's Justice of the Superior Court of Justice, attend now and you shall be heard. Long live the King, the Honorable Justice Hennessy presiding. You may be seated.
Good morning, all. So first, sort of an apology that we missed yesterday. I don't know what else to say about that. And I also understand it's very warm in this room. So our court registrar is going to be the keeper of the temperature and let us know if it hits too high going on. We might try that. The windows are open. Does it make sense to have the doors open or not? Are the corridors? Because I don't think there's anyone else around. No, you're not in my way. Where's the witness box?
Everything shut down.
Okay. So this might help. Okay. Are we ready to start?
It's Dr. Von Gernit's day,
Yes.
as we know. We have reached an agreement. It was sent to you, I'm going to say Wednesday or Thursday of last week. It is up on the counter somewhere. And I will refer you to what I submit are the key parts in it. Being paragraph 1A, agreement as to the qualifications you see there in 1A, Your Honor.
Do I have,
Oh,
what is the document
it
I'm to
looks
have?
like this.
Is it the CV? Is that what it's called?
Expert qualifications.
Not yet.
There
Thank
are
you.
2 letters. November 16th, 2022. Those by
Thank you.
agreement with my friends are submitted to you for context on the agreement.
So firstly, I'm looking at
1A.
the document called expert qualification,
Yes.
and I've got 1A. Thank you. Okay.
And then perhaps as or more significantly, paragraph 3. We say no party will rely on findings, opinions, or conclusions made by Dr. Von Gernit that are inconsistent with the stage 1 and stage 2 factual findings or legal conclusions of the trial court or court of appeal for the purpose of proving the truth of facts or asking the court to make any decisions which are irreconcilable with findings or legal conclusions already made in stages 1 or 2. Subject to that proviso, all parties shall be free to make such submissions and closing arguments as they consider advisable, respecting the use of and weight to be given to the reports and testimony of Dr. Von Gernit.
Right. And who will identify if there are opinions or conclusions that are inconsistent or irreconcilable with the
I
decisions?
anticipate that at that point, given the agreement, it would be done in the closing submissions.
Oh.
If the line was stepped over and some of the evidence from today or this week was used contrary in somebody's view to paragraph 3, that they would make that submission at the time.
Should I presume then that it's not your intention to elicit such evidence? Or
It's
Dr.
not-
Von
It's
Gernit
not so
to
much
use
the
it?
evidence per se, it's the purpose for which the evidence is being used. So we have to elicit, we will definitely elicit all of his evidence, but we're not doing it to, as it were, collaterally attack anything that's been decided before. That was the concern.
Yes.
As you know, hearsay being an example, there are many purposes for which things can be used, but we're not using them for any kind of attack on earlier findings. And so that's just something we wanted everyone to understand. And that was the principal concern.
Right.
So
just thinking this through from where I sit. Does it make sense that if there's a point where you are knowingly or intentionally eliciting or receiving evidence that is irreconcilable with the decisions, that you identify it as it comes in and saying, we don't intend to use this? Or,
that would make for a pretty chalky examination, I think, Your Honor. I would be constantly, I think, trying to judge on the fly whether something might be considered a collateral attack. As I'm just saying collateral attack, so I don't have to keep repeating what's in paragraph 3, right? We're trying to make this whole thing smooth, as we've been trying to do all the way through. So we'll avoid objections and just get into the evidence and make the arguments about weight. And we've undertaken basically in this agreement to stay away from using that evidence to upset or attack stage one or stage 2 violence. So,
okay,
yeah.
Mr. Schacter's on his, once you're finished, Mr.
No,
Marcel.
that's, I think,
Okay.
What might be helpful to the court, and I understand the question, the concerns about how do we sort of sort all of that out. The 2 letters that are provide context might provide some answers to the court, maybe even some, I'm gonna call it assurances, but provide context in which the Ontario intends to use the evidence, and might answer some of the questions the court has, and I think are going to obviate me standing up saying that's already been decided. Because it's really, really hard at this juncture for me to know at the end whether they're going to use inconsistent evidence for
To know the
evidence that-
purpose.
for a different purpose. And I can only think of one example, but the decision is what the decision is. The Court of Appeals said what the Court of Appeals said. But if the question is asked independently, what did a certain actor think in 1873? That could be inconsistent with what the court's already decided. It doesn't, he may have thought that, but if that evidence is elicited, I'm not sure what purpose it would be elicited for.
Mhm.
But I'm trying to give my friends the latitude to bring their cases, they understand it. And I have to confess, I might not understand it, but I'm hoping that these 2 letters from the first letters from Kathy Boyce Parker, in which
Should I take time to read these?
I think you
Letters?
should. I actually think you should. It might help clarify things for you.
Okay.
It's a letter written by Kathy Boyce Parker that I participated in authoring, that went to Canada and then Ontario. Then Ontario responded. I'll leave it up to Mr. Marcello as to whether he wants you to read it, but I thought it might be instructive.
Your Honor, if I may so submit, to keep this clean, there is a difference between calling the evidence and making argument. We have no intention of arguing what this evidence means during Dr. Von Grenet's examination. We're not going to.
Oh, no, of
We're not
course
going to
not. You're
argue
not
what it
arguing
means,
during.
But we have to get
examinations.
it out, and we'll argue it later, and my friend can respond to it because of the way the closing arguments are structured. There will be some opportunity for that, as I understand it.
I'm just asking now, does it make sense for me to take 10 minutes and read these? So I don't trip along with asking questions that are already
Sure,
solved as
sure.
between you.
But the overarching point again is paragraph 3. Whatever the letters say,
Yes,
the agreement is to streamline the trial so we can call the evidence and not have a bunch of interruptions, because there would be a lot if this agreement had not been made.
Right.
Possibly.
okay.
So but sure, we can stand down however long.
From what I am hearing, these letters might bring me comfort as to how much you have worked through this. And
They might explain why we agreed to
Okay.
the admissibility of the report.
okay, why
Again,
don't we just take a break?
Sure.
For 5 minutes? And in the meantime. Okay, we'll take a break.
All right. Is court recessed until recalled? This court will now resume. You may be seated.
Thank you for that time, and I was very happy to have those, have a minute to read that correspondence. What's your intention, Mr. Marcelo, to mark these as exhibits?
Yes, we've marked them as the next, well, mark the agreement and the letters as numbered exhibits. And, you know, subject to your direction, mark the reports as numbered exhibits as well.
Okay.
And then if there's no issue from the bench regarding qualifications or admissibility, which I'm sensing there isn't, I would begin the doctor's examination still on some points of qualification and explanation, but not anywhere near the level, of course, that I would if it was like a real voir dire, so to speak.
With respect to the qualification, I'm expecting that you will file the qualification on consent.
Yeah, the qualifications agreement would be marked and filed on consent, and
I
the letters
don't.
can go along with it.
So far, that hasn't come up yet.
The expert qualifications is found right
Right.
here.
That is the qualifications
That was
agreement. That's the one I read out.
Oh, that's,
That's the one I read out.
is that the one on, is that the, I had a letter from Mr. Rankin, or was it just that this is going in on consent? Mr. Schachter, is that?
Yeah, my friend had indicated that the qualification statement and admissibility is going in by consent, and that's fine. It can go in by consent. And the letters of November 16th and November 25th, they too can go in by consent, but we have to be clear that they are not being tendered for the proof of their contents, but merely for context for the court.
Oh, the
letters,
correspondence.
Letters, right? I mean, I wouldn't want to get into an argument at the end of the day that anyone agrees with either my, or that the court must accept as a found fact. Anything set out in the plaintiff's letter or in Ontario's letter, it's simply just context.
All right, thank you.
I'm being told, Your Honor, from distant galaxies that I'm not being heard well. So I thought
Do they have anything to say to me?
No, apparently not. But I thought we were okay in terms of volume, but so if I amp it up a little bit, that's why.
Okay,
There's some issue.
and on facilities questions, when we had a break, this setup is very difficult for me because my screens are over here.
Right.
And the witness box is over
Right.
here. So at 12:30, they can do that switch. So I'm thinking, depending on how everyone is, that we just start now and go through to 12:30. Does that sound doable?
Yes.
Okay, so we'll try that. So let's number these exhibits then if we go.
The expert qualification will be exhibit 47. John, are both these letters one single exhibit?
Yes, please.
Okay, that would be 48.
So. Sorry, 48 and 49 or just 48
47 and 40.
for the two letters?
The two letters, one single exhibit?
That would be fine.
Perfect, 48.
Correspondence between council with respect to the reports of Dr. Von Gernet.
Sure, that's fine.
How are we doing out there, officer? We have a game, do we have a game going on out there? All right, just see how it works. All right, and is there another one?
So that's the qualifications and the letters. Then there would be the so-called just demands report, the short form of the report, Dr. Von Gren, that's the big one. That would be marked as the next numbered exhibit.
This is just demands?
Yeah, there's,
This
Wanna
is
do-
PowerPoint.
This is
Okay,
two volumes.
I've got a big, super thick one.
that's it. So that'd be 49.
And you called their just demands?
That's fine. This is
Okay.
a short one.
And then the next one,
Would be the Anishinaabe Principles Report.
right?
Short.
Share a
Perspectives.
second, please.
We just call that the perspectives.
Perspectives
report.
report. Thank you.
Perspectives report.
Yep,
Thank
that's,
you, Your Honor.
that's 50.
Correct, Your Honor.
Now, there is a CV, an updated CV from the one in the reports. It doesn't change much, but it changes a little. I can authenticate, when I call Dr. Von Grenert, I can authenticate that and we can mark it then. There are 2 decks of demonstratives, one for each report. We could mark those as the next numbered exhibits.
I rise with the question. If there are 2 decks, we only receive 1 deck.
Agreed. I only
There's
have one
I'm
deck.
sorry, it's one deck. They're merged
Okay.
together now.
Sorry, what did you say about the CV? You'll put it in after you put the
Well,
witness on the
I'll
stand?
call, I can put it in now, but I mean, I was planning to
Okay.
put it to him and I'll just mark
Why
it
don't
down.
we put it in by consent now?
All right, the CV,
CV, then you want that to be 51?
52.
sorry, what's 51?
Well, you want the
This-
demonstrative, the deck, then the one deck is 51. Okay, and then 52 would be the updated CV. Is that right?
Correct.
And with respect to the demonstrative evidence, we have sometimes made them numbered exhibit, or sorry, lettered exhibits until the evidence is over. Make sure that everything is called, or how are you?
For Dr. Von Gernert, I would prefer if we just call this a letter exhibit for now.
Okay,
I haven't seen, I mean, this is a touchy subject.
All right.
Uh,
what
let's
letter,
see how it goes.
what letter are we at?
P. And this is for the slide deck.
Slide deck.
Thank you.
Mr. Shackman, I just have you pull your microphone a little closer to you.
My apologies.
Somehow I've lost 51. What is 51?
Right, the deck was supposed to be 51, Your Honor.
Oh, no, let's take the CV as 51.
Okay.
Dr. Von Gernert's CV.
Thank you.
And Exhibit P, for now, Mr. Marcello as the slide deck.
I think that's it. We're fine. I don't think there's anything else, Your Honor. In terms
Okay.
of housekeeping, I think
If
that's it.
you're going to take Dr. Von Gernert through his CV a bit.
I will. The reports are in. He's qualified. I'll take him through it somewhat.
All right, and I'm going to ask you if during that time you would deal with the matter that we're dealing with each witness and ask him if he's content to waive his copyright in his report. as we have had for all the witnesses so far, possibly except Dr. Booth. You'll remind me, someone. Did we do it? Okay, we'll check. So,
I'll do that.
all right, so we don't have to remember at the end. And with respect to the qualification, as you go through it, I'll just ask you to then ask the court for that qualification. So then we put it on the record what what he has been qualified as.
So
And it
we
may
can
be-
do that now. What we would put on the record, I would suggest would be exactly what's in the agreement with my friend. The qualifications are spelled out in paragraph 1 of exhibit 47, I think it is. Is it 40? Not, maybe not 47, but the agreement, whatever the qualifications agreement, I think that is 47. Paragraph 1, those are the qualifications. You'll see they differ ever so slightly from the qualifications typically used in connection with Dr. Von Gernot as appear in his CV, but in no substantial way.
So you seek that the court qualify Dr. Von Gernot as an expert in the terms set out in Exhibit 47.
Correct.
Thank you. And so qualified.
So he's qualified, the reports are in. May I call him then?
Please go ahead.
He needs to be affirmed.
Alexander Von Gernot, B-O-N, G-E-R-N-E-T.
Do you solemnly affirm that the evidence to be given by you to the court touching the matters in question between the parties shall be the truth?
Yes,
Morning.
To begin, Doctor, there are copyright issues concerning the reports. Do you waive those? Do you have any issue with waiving those?
I have no issue.
I'm going to take you through some parts of your CV and other parts not so much, for obvious reasons, I hope. And I'm going to take you a little bit into one of the reports, more into one of the reports than the other. Beginning with your, I guess, PhD. This appears a discussion of it or a summary of it in item B in your CV, number 3. Can you just tell us a little bit about the background to that PhD, please?
Yes, I'm an anthropologist by profession and training. And so my doctorate is in anthropology. But the specialization within that is in both ethnohistory and in the archaeology of indigenous peoples in North America. And so I wrote a PhD thesis that was not on a specific culture, as is often done, but rather on a particular indigenous practice that was universally practiced throughout North America. And so my research covered indigenous peoples throughout the continent.
The fellowships, awards, etc., including your gold medal standing as an undergraduate and so on, these are all set out in paragraph C. And I take it there's nothing you want to correct in section C?
No, there's nothing to correct.
In terms of page 2, the section called academic appointments.
We're on exhibit
Page-
52.
We're on the CV, which is 51, I think, it ended up being
It is correct.
51. Page 2.
Got it. Thank you.
And there are a number of academic appointments indicated there, obviously, but I want you to elaborate on the 10th one, please, where you seem to have some kind of an editorial role. Could you tell us about that?
Yes, I was the editor of a scientific journal known as Ontario Archaeology for many years. And that involved looking at scientific papers that were submitted to the journal and supervising the peer review process because those papers then had to go out and be reviewed, and then I had to make decisions as to whether they met the highest standards of our profession. And then I also personally edited many of these submissions for publication. In the course of doing that, I came to understand both the limitations and the strengths of the peer review process. And I also designed a set of standards for the submission of academic papers to this journal.
And you did that for some 5 years, it seems,
Yes.
and you didn't do it any longer. For what reason?
Well, I had many other responsibilities to deal with. I thought, 5 years was enough, and I resigned from the editorship.
Now, we go into the next section here, still on page 2. It's called University Teaching, and there are some 16 items listed there. Would it be possible for you to use your judgment and tell the court which, if any, of these teaching areas might have more relevance to this case than others?
I suppose number 9, that was a course that I taught for a very long time, for decades. It was at the time called Aboriginal Peoples of North America. Today, of course, the term Aboriginal is slowly being replaced by Indigenous and other more appropriate terms. But in those days, it meant the same thing, but was just a different terminology. And that's a general course that I did at the University of Toronto, Mississauga, a very long time. And that involved a whole history of contact between Indigenous peoples and European newcomers throughout North America. But because I live in Ontario, my focus when I use examples has always been either Haudenosaunee or Anishinaabe peoples, because they're sort of considered to be the local Indigenous population. And so my students and myself had more interest in that than in many of these other cultures that we also covered more superficially. These courses that I teach are sort of give an introduction to how we go about reconstructing the past, because my interest is less in the modern Indigenous context as it is in the past. And so I use ethnohistorical methodology, and I teach that or taught that for many years. And it involves a combination of 3 species of evidence. The first being archaeological.
May I ask you just to maybe slow down a little bit?
Sure.
Thank you.
So ethnohistorical methodology in its classic sense requires every species of evidence that we have available. And the three major ones are archaeological data, written documents, and oral histories and traditions. And whenever we have those available, we use those in methodological conjunction. In some cases, of course, the archaeological record is irrelevant. In other cases, it's the most important piece of evidence. In some cases, there are no oral histories or traditions, and so they become less important, obviously, than some of these other species of evidence. The important aspect of this is to understand the critical approaches one uses to ensure as much as possible the reliability of the source materials that we do have. And so that number 9 on the list of teaching was sort of introduction to all of that. And then number 10 was a more advanced course in which I taught basically the same principles, except this time tracing the same methodology through the subject of change and continuity in Indigenous societies. Because Indigenous societies, much like any society on the planet, undergoes change over time. And so there's a continuity portion and then there's a change portion. And as anthropologists, we're always interested in both. There's no society that remains static in a single point in time and then never changes. The archaeological record in Ontario alone is evidence of that, because what Indigenous peoples did 1,000 years ago here looks very different than what they did in the 18th century. So those are the kinds of things that I taught there. Number 13, those are all independent study and independent reading courses, and those are mainly, I had advanced students who, it's basically one student per professor. So it's a one-on-one, and so each subject is different. But there were a number of studies that I did with those students relating to both Anishinaabe and Haudenosaunee, the two main groups who are the main representatives in Ontario of the Iroquois and Algonquin language families. Number 14. Back in 1993 or 1992, I first began testifying in courts. And this was a result of my mentor, Bruce Trigger, having testified in the Adams case in the 1980s. And I was his graduate student and assisted him in that. And so I was, from a very early time during my graduate studies, I was already exposed to the way in which anthropological evidence is used in forensic contexts. And so after I graduated, and my professor suggested that whenever he got a phone call, he just simply kind of tell the interested party to contact me. I started getting phone calls from all over the place asking for expert evidence. And so I started getting very much interested in how anthropological evidence is used in Indigenous cases. And so I developed a course around that at University of Toronto, Mississauga. And that's why it's called Forensic Anthropology and Aboriginal Peoples. It was basically on how anthropological knowledge is used to try and assist in legal issues. So, we worked a lot on confirmation biases and the way in which, research is conducted, the role of oral histories and traditions. I did a lot of work on that and subsequently published on that subject. And so overall, that formed a considerable portion of my interest starting in the early 1990s and continuing to this day. Number 15. That's another course along the same lines. It was just renamed, but it basically had similar content. And this, a lot of what I've done over the years, it has been either Aboriginal rights cases or treaty rights cases. And the Aboriginal rights cases, of course, make the archaeological part of the research important, because the test is to go back to the time of first European contact. So we need to reconstruct these cultures at the time of contact. Whereas the treaty rights cases, they involve dates that are much more recent. And so I've done cases from involving treaties in the United States in the 1600s, the 17th century. And I've done cases involving treaties in the 18th century and the 19th century and the 20th century. Treaty 9 in Northern Ontario is 20th century. And of course, the Williams treaties in 1923 are also 20th century. So my research has taken me through literature spanning the centuries. And of course, each century has a different historical context, which makes it intellectually fascinating.
Thank you. There is only one more item in this part of your CV, Dali Lana. I take it you don't wish to comment on that in particular?
Well, I mean,
It's not
that's a course that I still teach, except that the COVID kind of interrupted
right.
that. Because I did a PhD on Indigenous uses of tobacco. The Public School of Health asked me to teach a course at U of T. It's a graduate studies course, although I don't teach the entire course. I only teach the historical portion. It's a team taught course.
And when we're on page 4, we move into section F, archaeological field work. I recall reading from your stage 1 testimony that this sort of work, it positioned itself pretty early in your career, and you moved off of that into ethnohistory, I guess sometime in the 80s. Is that the right context?
Well, it's true that most of my archaeological work was done very early in my career, but I have more recently returned to it because I have Indigenous clients who are very interested in using the archaeological record in it to advance certain potential claims. And so I've renewed my interest in that very recently, but I didn't do any field work in the interim. I've kept up with the literature, but I haven't actually got my hands dirty since the 90s.
And as you mentioned, Indigenous clients, can you comment for us on your client base in general terms?
Well, it's judging by all the cases that I've done, it's mainly the Crown that has contacted me over the course of decades. I don't solicit any of these, and I have the luxury of picking the ones that I think are intellectually satisfying to me. That said, I also have inquiries on a regular basis from council representing Indigenous peoples. And I've taken on some of those as well. None of them have resulted so far in action in a court appearance. But I have had in the past, and I currently have Indigenous clients, including Anishinaabe. But you'll be pleased to know that they are not plaintiffs in this proceeding. So there are many Anishinaabe peoples, and it's not just the ones who are involved in the Robinson treaties.
Now, laboratory and museum experience, is there a thumbnail sketch you can give of what that is? in your
I don't think
career?
that really has much relevance here.
Moving then to consulting, I would, I guess, go into the subjects. That's on page 6. I'll just wait a second.
I've got it.
Page 6. Again, same kind of question, Dr. Von Gernert. Are there any entries there that you think have particular relevance to the case we're doing now?
We're talking about
Consulting subjects.
Yes. Yeah, again, I mean, the first 3 are obviously, as I said earlier, the important species of evidence. And I've done considerable work using all 3: written documents, archaeological evidence, and oral histories and oral traditions. I've also done considerable research on the reconstruction of practices in the history of contact between natives and newcomers. And I've done a lot of work on the history of treaties and reserves, Indian statutes, Indian policy, particularly 19th century. And also something that has come up from time to time are methodological issues relating to Métis identity and ethnicity.
And in terms of the research aspect below that, is there anything in there that you want to comment on for the assistance of the court? Or should we move on?
Well, the group's research include the Anishinaabe, obviously, because I've done work on what is otherwise called Ojibwa, Chippewa, Saulteaux, Mississauga, Amiquah. Those are all what may be more properly referred to as Anishinaabe, in the sense that it's not a polity, but rather a language. And they all belong to that same language, or speak the same language or dialects of that language. The Algonquin as well speak a dialect of the same language, although not all of them refer to themselves as Anishinaabe.
Anything else?
No, I think that's it for the group's research. As I said, I don't confine my research to one particular group, because the skills of my profession have transfer value no matter where you go. And so I'm often asked to research groups that I have less previous exposure to. So many of those are listed. And over the course of doing years of research on these, you acquire a tolerable degree of understanding, as much as a few years of work will give you.
Right. When we get into expert witness, this is again at the bottom of page 6. It's item I in your curriculum vitae.
Yes.
And it goes on at some length. Are these These are all cases in your career in which you've been qualified to give expert evidence, I take it?
Yeah, there's 36 of them. There are some previous ones, obviously, that are specifically related to the Anishinaabe. 3, 11, 15, 24, 27, 30, and most recently 35. And then, of course, 33 was my first appearance in these proceedings at stage 1. So
Right, back in 2018, I see. So then your reports were admitted in all these cases in which you, in all the cases in which you testified or gave evidence?
all of the reports have been accepted. Now I must qualify that by saying that some of these earlier ones were in the form of affidavits and depositions, which were then used by court. So I didn't actually appear before court. They were done through a different process. But
Right. I see that in item 3.
yes, but yeah, item 3 is a good
I see it
example.
in 11, do I?
Yeah.
And 15? 3, 11,
Yes.
and 15?
So in other instances, of course, I was qualified on the stand and appeared before a court who qualified me. And that would be the rest of those Anishinaabe cases, as well as the dozens of others.
And at the beginning of the expert witness section, right under the heading, expert witness, it says general qualification statement. What is the significance of that entry?
That was more or less the qualification statement that I began with the very first case, and then after that it kind of became the standard in all other cases, with some exceptions that involve minor tweaking of the wording, because sometimes some counsel or judges prefer to have either more specific or broader qualification statements for whatever conveniences there may be.
Right.
But for the most part, that qualification statement as it reads is what I've been qualified under in all of these cases.
If we move through past the community-based experience, not to minimize it, but really, I guess, in the interest of time to an extent. And we move then on to quite a lengthy section, Dr. Von Gerndt, on page 9. It's called publications and reports. Now, as I said, there are a large, I think by any standard of judgment, number of entries here. I have 125 going up to 2022. I'm not going to ask you to comment on all of these, obviously. Are there any publications in this section again that you consider to have particular relevance to this case?
Sure, I can narrow it down. Number 21. That was a case, or report, I should say, that I submitted in a case involving a saurage ban. And it involved their practices and understandings before and after they signed their treaties with the crown. These were the number treaties in the 1870s. So that's when I started getting exposed to 19th century treaty making in Canada. Then number 32. That was a research report that was published by Indian and Northern Affairs, as it was then called, specifically on the subject of oral narratives and Aboriginal past. It was an interdisciplinary review of all of the literature on oral traditions and oral histories. And I was asked to write that because, you know, as an anthropologist, I had been exposed to that subject, obviously. And so I dug into the literature and did an extensive literature review on how oral histories and traditions are used as a species of evidence in all different contexts. Number 39. The Chippewas of Sarnia Band and the Cameron transaction. That was a brief report I did. As I said earlier, Chippewas is a, if you say the word quickly, it sounds like a Ojibwa because it is the same word, just spelled differently. And they are an Anishinaabe people, so they self-describe often today as being that.
Sorry, Doctor, could I ask you just maybe keep your voice up a little more?
Yes, certainly.
Thank you.
And that involved a transaction going back to the early 19th century, 1839. The next one, I guess, would be 47. That was a study of the history of Canadian Indian reserves, how that whole system was set up, and sort of the background to the reserve system. And then in this case, it was specifically in relation to what was alleged to be a reserve that has been set up in Newfoundland among the Conne River Mi'kmaq. Number 50. This dealt with the historical context of the Cayuga treaties. These were treaties in the state, what is now the state of New York. Those are late 18th century. Number 2000.
Number 2000.
I'm sorry, number 52, the year 2000. I haven't done 2000 publications yet. I don't think I'll live that long. That was a peer-reviewed publication specifically on the role of oral traditions as evidence in Indigenous litigation. And consequent to that, there were a number of cases that I testified in which that approach was tendered by myself as an expert and was accepted by various courts.
You recall, I mean, it might be
Well, there was
fair to ask, you recall? the
yeah,
names of any
there
of
was the Drew case, which was a really big case in Newfoundland. There was also the Benoit case, which went to the Federal Court of Appeal, which also accepted my approach to oral history and tradition. On the other hand, the Chilcotin case in British Columbia, that court, as I recall vaguely, somewhat misconstrued what was my well-documented and published approach to oral histories and traditions.
Who misconstrued it?
I don't recall, but it was in the Chilcotin.
Yes,
case.
but when you said they misconstrued the court.
Oh, the court, yes, I think, as I recall, although I mean, that's fine with me. It's not something I have control over. In any event, so I mean, some courts praise my approach, others either ignore it or don't find it useful. That's fine. I'm not here to criticize one way or the other or defend one way or the other. All I can do is provide my evidence to the best of my scholarly profession and to the highest standards that I think are appropriate. Where are we?
We were at number 52
Yeah, number
on
52.
page 12.
Yes, so the next one, I guess, would be 57, yes. Again, this dealt specifically with oral documents in Treaty 6. That was in the Chief Victor Buffalo case. That was a case in which I discovered the transcripts of oral history of Indigenous elders that had been recorded in the 1970s. And then the same witnesses have been recorded again a decade or two later. And I could trace sort of the history of the changes in these oral traditions, which is really quite fascinating, because it turns out that these oral traditions were often related by the elders in the context of the modern lens that they were seeing the world with. And that became an important point in that particular case. Now, number 56 is another interesting case on how the testimony of Indigenous elders must be scrutinized with a rigorous approach, because it was a case of an elder giving a story about an arrangement that had been made between the Mi'kmaq and the French in the early 17th century. And he produced a wampum belt that his grandmother had interpreted for him, and he testified as to what it meant and what the agreement was and so forth. And then subsequently, I found the original belt in the basement of the Vatican, of all places, and found the letters that had been sent to the Pope that explained what this wampum
Did you
belt
say
meant.
the Vatican?
Yes, the Vatican in Rome.
Yeah.
Yes. And I found the original letters and the belt itself, the original belt, and wrote a report and testified to the fact that this belt was not Mi'kmaq to begin with, that it originated in what is now called Oka or Kanesatake, and was sent by the Algonquin and Mohawk of that community, and had a completely different meaning assigned to it. So that was kind of a cautionary tale that got me to think that, oral histories and traditions and elder evidence is very important because it often has much to contribute. sometimes the short-term oral histories give entirely new insight into what happened in the past. That's different from what we might have from any other kind of evidence. And, a good example, I think, your learned friend, Mr. Schachter, as it well knows, because he was involved in this. I did some interviews with elders in northern Saskatchewan in a joint expert opinion in which we were amazed by the amount of knowledge, the rich knowledge that the Dene people had. And we videotaped and interviewed them and wrote a report.
Excuse me, to me, you're trailing off just a little bit. I'm
Yeah,
sorry.
well, I wrote a joint expert opinion in a case in which we examined some of these oral histories of the Dene elders that we had interviewed and tape recorded. And it was very valuable because they were close to the land and they knew where their ancestors had hunted and fished. And so I'm certainly not a critic of Indigenous elder testimony. I just have always been of the view that there cannot be a double standard. You cannot look at that species of evidence with a different standard of rigor than you do written documents, because we apply very high standards of rigor to examining the written sources.
Any other entries here that you think have? I think you went from
Yeah, so there's
57 to 50.
yeah,
excuse
so
me,
there's
57,
59.
56, and
Yeah, I'm sorry, there's 59, there's another oral tradition. That was a treaty 8 case. So again, a numbered treaty case. I've done a lot of I've done almost all of the numbered treaties in one case or another. Let's see. 65. That's a Treaty 6 case, but again, it was specifically on an assessment of the written and oral evidence. So the oral traditions and the written evidence and kind of comparing them. So that's again, that's the Victor Buffalo case. There's number 69 that dealt with the so-called Saulteaux tribe. That is a Treaty 3 group. They are Anishinaabe. And that dealt with specific issues relating to the aftermath of Treaty number 3 in 1873 and their entitlement to a reserve. So that's what was at issue there.
and this is the area to the west of our treaties.
Immediately to the west of, if you go from Thunder Bay and you travel west to using the Rainy River route, you end up at Fort Francis. And that's where the trial was, and that's also where the issue was about reserve entitlement under Treaty 3.
Any others?
So again, as a consequence of that, I went through a lot of the literature involving the Anishinaabe understanding of the treaty and how Crown officials understood the entitlement as well. Number 75. That's just another report on the historical context, this time of the Oneida treaties in New York. Number 77. That was in relation to the history of treaties and statutes and government policy relating to band membership. That was in Saurage Band, that would have been by at least Treaty 6. So
Band membership, if I'm recalling your report correctly, issues of membership arise in our treaties in this case?
yes, they arise in all treaty cases. Issues of who is and who is not a member entitled to the benefits of treaty, whether it be the reserve lands or annuities or whatever other stipulations there were. That's
Well-
always been a matter of dispute all over Canada. Doesn't matter where you go. I see the same issue crop up over and over again.
Anything
In the
further?
case of in the case of the, I mean, in the earliest case I did, very first case I did way back in the early 90s, was an issue about whether it was an issue about Bill C-31, which tried to get rid of the discriminatory provisions of the Indian Act. But in the original 1876 Indian Act, discriminated against women blatantly because women would, when they married out, lost their band membership, right? And not only that, but they lost their Indian status.
Yeah.
And so Bill C-31 was supposed to rectify that to some measure. And I was called in as an expert witness in that case, in which a band claimed that, how dare you pass Bill C-31? Because in our culture, we always discriminate against women. And so I was called in to debunk this notion that somehow these Indigenous peoples had discriminated against women prior to the Indian Act. And their argument was that the original Indian Act was in accord with their own practices. And that was all about band membership, because there were oil revenues involved and they didn't want to share them with women who married out, and it gets complicated. Anyway, so I've been involved in band membership issues for years. It's been a fascinating journey in that respect.
Well, perhaps we'll address it more later. Any other entries here?
Let's see. '79. That was a peer-reviewed publication.
That's your mentor there?
Yeah, Bruce Trigger. This was what in the academic community we would call a Festschrift.
Sorry, what was that?
A Festschrift, it's a German word, Festschrift, Schrift, Festschrift. It's sort of an acknowledgement of the career of a very prominent Canadian in this case, who regrettably passed too soon. And he was my greatest influence. He was my mentor for 8 years. I studied under him he only had 12 PhD students, and I was one of them in his whole career. And we were very close. And he's the one that got me into this whole thing. He was an extraordinary ethnohistorian, a world-renowned archaeologist, an Egyptologist, wrote the definitive book on the history of my profession. So this was an opportunity to sort of talk about his influence, particularly in relation to work I did on oral histories and traditions. Number 80, that's a very related article. It was also peer-reviewed on how we reconstruct centuries-old events.
Related to 79, you mean?
Yes, related to 79. Number 80 is related to 79. Yes. It's another article along the same lines. 81. Again, dealing with strengths and limitations of oral histories. Number 82, sorry, that's not relevant. 84. Again, that's oral history and oral traditions. Number 91. That dealt with treaty number 3 again, 1873. That was an examination of all the primary sources relating to treaty number 3 in 1873. With the view of illuminating the understanding of the parties. So it was specifically intended to try and reconstruct what the parties understood. 95. 95 is a really fascinating one and an important one. Number 95 involved the 1923 Williams treaties. And as your honor knows, when I first appeared before you, I was retained by Canada. Ontario subsequently, with Canada's permission, retained me for this phase. And the reason initially was because I knew a great deal about the boundaries of the Robinson treaties. As a consequence of doing all this work on the Williams treaties, because the Williams treaties happened to overlap with the Robinson treaty, the RHT, the Huron version. And so that's how I originally got involved in this phase 3. And so I started working originally on trying to figure out what the boundaries were. In any event, the 1923 Williams treaties are important to me because in the course of doing extensive research, I learned about the entire system of pre-Confederation and pre-Robinson treaties in Upper Canada, because that's what the Williams treaties were supposed to clean up. That's why I called it a cleanup treaty, because in 1923, things had gotten to the point where the Anishinaabe, known as the Chippewas and the Mississaugas, were upset because of all of the irregularities in these Upper Canada treaties, and so that there was an effort to clean them up in 1923, and at which time an agreement was reached that they would no longer an agreement was reached in which they were compensated for all of these issues relating to the Upper Canada treaties, plus for lands to the north, which, as I said, overlapped with the Robinson treaties. The Williams treaties went all the way up to the French River, and so included everything along Georgian Bay, from Georgian Bay all the way to the Ottawa River. So there's overlap there, and that's how I originally got involved in this, is because I knew this, the primary sources relating to all of this very well. Number 98 involves, oh, and I should add before I leave the Williams treaties that we did extensive joint expert opinions in that case, which were very valuable, in which experts on both sides would get together and produce expert opinions, including opinions on a vast corpus of oral histories and traditions. 1923 is a lot more recent than 1850. And as a consequence, there were a lot of oral histories and traditions that we had. There were still people whose grandparents had been there. So number 98, that's again a Treaty 3 case. I'm just going to quickly go through the rest of these. Yeah, number 100, that's one of these co-authored joint reports related to Alderville. And I should add that I was qualified to testify, and I testified for weeks in that case. And I have no idea what happened to it. Nobody's ever told me what the.
They'll tell you over lunch.
Okay. I mean, I was never informed of what it's like. I was, looking for a trial decision, and I had no idea what happened. So in any event, so again, 100, 101, those are both related to that same case and are joint expert opinions. 103 as well. The Williams treaties are interesting because we found the original in the archives in Ottawa, and it had been changed. So there was an issue of what the treaty actually was. I mean, we used high-tech equipment to analyze the words that had been changed. It turns out the changes were inconsequential, but still it was rather alarming to examine the original engrossments, which we did as a team, experts retained by all parties. And 105, that involved, that's a Fletcher case. A decision was made in that case, and that was a very interesting case as well, because it involved not only Cree, but also Anishinaabe. This was a Treaty 9 case. And
Now they're north of.
yes, this isn't just north of the Robinson treaties, immediately north. They butt up against each other. The Haida land separates the Robinson treaties from Treaty 9.
Right.
And the only reason there is a distinction is because the limits of Upper Canada did not penetrate north beyond the height of land. That's why the Robinson Treaty stopped there. The rest of it was considered to be Hudson's Bay Company territory. Although the Cree and the Anishinaabe who lived there would have disagreed. So that was also in a case in which I not only wrote my own expert opinion, but also joined my colleagues in joint expert opinions, which were then accepted by the court. We actually did a very interesting setup because we had a room in which the court ended up sitting in the witness box, and we sat on the bench, the three of us. It was very bizarre.
You testified as a panel?
Yes, we testified as a panel, literally as one voice, although we took turns.
Is that it?
So almost, yeah, I think.
Did you say that was 105? Where did you test, in which case did you
Yes,
testify as
that
a
was the
panel?
Fletcher case, 105.
Okay, thank you.
Yeah, Chief John Fletcher versus Her Majesty the Queen and Right of Ontario and the Attorney General of Canada. Uh, 107 was a case involving treaty annuity payments. Number 108, or I should say 109. That again was the Fletcher case. Another report, a joint expert report. 111, I prepared an extensive 201 page expert opinion on oral histories and traditions of the Anishinaabe relating to the 1923 Williams Treaties. And then number 112, it was on the same subject, but co-authored with my colleagues who were retained by other parties.
You at the end of page 18 now?
Yes, I turned the page to 19. Number 117. That's the one that I referred to earlier, where we interviewed the Dene elders. That was in relation to the Cold Lake Air Weapons Range. Number 118. That dealt with Treaty 4 reserves and matters relating to oral histories and traditions. Number 119, that was a very interesting case because I wrote a 417-page report on the Amaqua, who are otherwise known as Beaver people. They are an Anishinaabe group that was identified by the Jesuits in the 17th century, but they no longer existed by the end of the 18th century. But today there are individuals who are claiming this Anishinaabe ancestry through the Amaqua. So I wrote a huge report on that. I never got to testify because the expert witness for that group, who was a prominent law professor, and whose report I was responding to, ended up being disqualified by the court. And so there was no evidence to give, and my response was superfluous.
All right, is that anything further?
No, I think, with the exception maybe of 122, I did an opinion for Canada. I'm not sure what's happened with that, but that dealt with specifically with the Nipigon band, which is an RST band.
All right, does that complete your
Yes.
identification in this section?
Yeah, there are others, but I think that's it.
Let's go to the conference papers, and I'm going to ask you this same thematic question I've asked you. This is the third time now. Anything in these that bears comment from you in relation to this case?
I don't think it's really necessary to go through those. It's basically a repetition of the same thing, except these are invited lectures that I did on the same subjects that I've already written about and testified to today.
I don't have any, unless Your Honor has any points of clarification. I don't have any further questions arising from your curriculum vitae, Doctor. I know, Your Honor, you wanted to break at 10.
No,
At noon.
at 12:30.
It's 10 to at 12:30.
Yes,
Oh, I'm sorry, 12:30. Okay.
if that's worked for you.
Are you, Doctor, are you all right to?
I can manage till 12:30.
So we'll
Press on.
Yeah, we'll press on.
You touched on this, and maybe you did more than touch on this, but I want to make clear that we all understand ethnohistory as a methodology, because there's no issue. I don't think I'm leading you improperly in saying it is a methodology. I just want you to flesh out for us what what its content is as a methodology. I recall you mentioned, if I understood your point, 3 subcomponents to it, one being archaeology, and I don't know if that's the guts of it or not, but can you explain ethnohistory as a methodology, please?
Are we past qualifications now?
Yeah.
Thank you.
Yeah, I mean, we're there. Yeah.
Go ahead.
Well, ethnohistory is actually not a field.
Unless, excuse me, unless you want me to formally proffer them, but we
No,
have the agreement.
I asked you to, and I've
Right.
accepted it. Thank you.
Right. Go ahead, I'm sorry.
So ethnohistory is not technically a field per se. In other words, you cannot get a degree in ethnohistory. You know, nobody has a diploma on their wall that says, you know, PhD in ethnohistory. Rather, ethnohistory is a methodology that is shared by anthropologists and historians. So you can have historians who are ethnohistorians, or you can have anthropologists who are ethnohistorians. And so the degree that you get is actually either in history or in anthropology. The methodology itself originated, believe it or not, in the period after the Second World War, when there was a demand in the United States for experts to opine on matters that were before the Indian Claims Commission in the United States. So historians and anthropologists started working on cases for that purpose. And that's how it actually started. It's sort of come full circle again, but in the intervening decades, ethnohistorians or people who are involved in this kind of work were working on many other subjects unrelated to judicial proceedings. And their main sort of what brings it all together, aside from making sure that you have all the 3 species of evidence and you're qualified to deal with that
Which were again?
the archaeological evidence, the written documents, and the oral histories and traditions.
Yes.
Aside from that, the main sort of way in which ethnohistory has progressed has been to focus on the study of change and continuity in indigenous societies from the time of their first contact to modern times. And ethnohistory understands indigenous peoples and European newcomers to be part of the same historical trajectory. We don't examine them in isolation from one another. Once they came into contact with one another, in the East, it was as early as the 16th century. Once that happened, there was a history that involved contact. And so ethnohistory has been primarily the study of contact between natives and newcomers, and more specifically, the study of sort of the changes and continuities in indigenous societies and their relationship to the European newcomers over time. There are, of course, ethnohistories that are practiced in other parts of the world, and I don't know how they define themselves, but here, this is how we would generally define this. The methodology that's used is one that involves sort of a synthesis of anthropological and historical skills. So as a graduate student, I was not just trained in anthropology, but also history. And so because historians traditionally were not so much interested in indigenous peoples at all. It was the anthropologists who were the ones doing scholarly work on indigenous peoples. Historians were more interested in the the heroic period of Canada's past, which was, where Native peoples were kind of the part of the natural backdrop to history. Whereas anthropologists who also had archaeological training studied Indigenous peoples going back to when humans first arrived on this continent. But bringing these two together, historians having the ability to deal critically with documents, bringing that skill together with the anthropological approaches, which included archaeology and the study of the traditions of Indigenous peoples. That's really why ethnohistory is a powerful methodology, because it brings these skills together to study, one historical trajectory that is shared, a shared one on this continent.
Anything else?
Unless you have any questions about it.
No, I don't. It was clear to me.
Oh.
Assume to everyone else. Now, you prepared two reports for this stage of the proceeding, Dr. Von Gernert. The first one, the long title is "Their Just Demand Should Be Met Without Further Delay, a history of government efforts to pay annuities specified in the Robinson Treaties of 1850. That's the first one, and that their just demand should be met without further delay. If my own memory serves me, is a quote from Blake, is it? Not the poet Blake, but Blake, the lawyer Blake.
Yes, the guy that started the law firm, still running today.
So he was an official with Canada. Was
Yes, he was, well, first he was a premier of Ontario for a short period of time, and then he moved to the federal jurisdiction and became a rival to Mackenzie, and ended up becoming the Minister of Justice. And the Robinson file came to his desk as soon as he became Minister of Justice, and he wrote an opinion on it. And the title of my report and the picture that you see on the front cover is his letter, or his legal opinion that he actually wrote on the annuity augmentations in the Robinson treaties.
and this led to the interactions with Attorney General Mowat and all that. It's all in your report.
Yes.
Now, the second report is called Anishinaabe Principles, Perspectives, Understandings, and Expectations in Relation to Sharing under the Robinson Treaties of 1850, right?
Yes.
So those are the two reports. Just Demands is Exhibit 49, I think it was.
Yes.
And it is broken down into 7 chapters. They are noted in the table of contents, unsurprisingly. And I would like you to give us only a thumbnail sketch for the moment, a thumbnail sketch of what you do, what you address in each chapter of their Just Demands report. Can you do that? Because we will go into these in more detail. So this is kind of like an overview level.
You're sending me to the second report, Mr. Marcello?
I think it was the
Or did you say the first?
the big
Oh,
one, the big one.
Okay, thank you.
I'm just on page 2 of it.
So my report was really intended to provide the historical context for what the Crown actors did subsequent to the signing of the treaty in relation to what they understood as the obligations to pay annuities. And also the down payment, because I started with the obligation for the down payment. So in order to flesh out that historical context, I basically started with the early period, how treaty annuity funds and land funds worked in the period prior to the Robinson treaties, and then how that system continued afterwards, and how the Robinson treaties fit into that existing system.
You're in chapter 1 here. That's your overview of chapter 1.
Yes. And then I moved on to actually the efforts to meet those Robinson Treaty obligations, including the distribution of the down payments, the mechanics of how this worked. I spent many months just trying to sort out the, how each penny was, or how each pence and shilling and pound was accounted for, and how that related to the way in which I had seen it operate in other treaty contexts. And so the goal here was really to see what did the Crown Actors do in relation to the treaty obligations, and why did they do it the way they did? And so I went through this process in chapter 2, and the down payments, the track the source of the annuity funds, the payments of the pre-augmented annuities, and their efforts to distinguish the annuity type treaties from the other arrangements that resulted in land funds. And then I tracked the proceeds, or I should say, I tracked government efforts in chapter 3 to try and track proceeds from the lands. So that's what chapter 3 is all about. And then chapter 4 involves the period leading up to and after Confederation, at which time the annuities were capitalized, and you began having these jurisdictional complications arising from Confederation, which resulted in arbitrations. And throughout this period, you still have Anishinaabe memorials and petitions, which I also looked at. And then in chapter 5, I dealt with the decision to augment the annuity, which started in 1873 and culminated in the actual payments in 1875. It's a very lengthy and complex process. And one of the things that I stress throughout is how at first blush we might think, this should have been a pretty easy task. It's not rocket science. You read the treaty and you start making payments. Well, that's not what happened. It turns out this is not quite rocket science, but it's incredibly complicated. And I took, a good 6 months trying to figure out what happened here, how this worked, and what was the understanding that led to the ultimate actions. So chapter 5 was then leads to chapter 6, which was the unfinished business. After the annuity augmentations were made, there was the questions about arrears payments. And that's where you get into all kinds of issues, including the RHT boundary and the government. There were so many delays in dealing with this issue But finally, there were statements made by Ontario in 1879 showing tracking the exact proceeds from the lands and comparing them to costs. And so I examined those in what I would suggest is exquisite detail, because and I don't know if anyone's ever done this before for this. I wouldn't have done this if I had found a document where somebody else had done it. So this is a consequence of ultimately, I spent much of the pandemic on this. It's holed up in my home office with no contact with the outside world.
We all have our stories.
Yes. So you can appreciate that I had the advantage of being able to focus, but the disadvantage of not being able to really to talk to anyone about my findings. It was a very challenging project.
I have a question for you, if I may. When you talk about arrears, what is the bracket here? 1875, you're going backwards, I presume, to when? But I'm not asking for a lot of detail, just the.
Yeah,
bracket.
well, basically in 1874, when they made the final decision that this should be augmented in the following year, they already understood at that time, the possibility that the full annuity might have been payable prior to 1874. So the only way to know is for them to go back in time and get the data and ensure that the arrears, if any, they had no idea whether there were arrears or not. They just didn't have, the data was just not of that level of specificity. All they knew is that by 1874, the annuities were due, the augmentations were due. And it was just a matter of going back. And so ultimately they did go back and through whatever records they had and ended up with figures relating to annuities.
From Confederation or from earlier?
Well, from earlier as well.
Earlier as well.
Yes, yeah, both pre and post Confederation.
And chapter 7, kind of a dumb question to ask what it is given the heading of it, but you're pulling together a lot of stuff there.
Yeah, that's just a summary. So what I did in this report, Your Honor, is I provided you with a convenient summary at the end of every chapter, because I know it's really detailed. I mean, I can imagine somebody sitting down one day and going through this from cover to cover in one sitting. So I put in
Have an
some.
imagination.
So I added these summaries, which hopefully are some help, and then I also provided a concluding chapter, which kind of not only summarizes the summaries, but also sort of adds my conclusions under different headings of themes that I found.
Let's go to the other report, the perspectives report. Madam Clerk, Exhibit 50, is it?
Perspective.
50?
Correct. Thank you.
I don't think I have it. Oh, here it is.
Now, I'm going to ask you for clarification and elaboration on certain content in this report. I'm not going to conduct a full examination in chief on this myself. I want to focus on a couple of key areas. The first of these is on page 3. I don't know whether it's worth you reading it out, but this in the middle there, this is your mandate.
Yes.
Maybe you give the court a moment. So now, Doctor, given, I guess, what I'll call some changes in the course of this case, I take it that the Boaker and Stark reports don't require any particular response by you? Your focus
Yeah,
now would be
I-
on Dr. Driven's evidence?
That's correct. I mean, this report that you have in hand addresses not just Dr. Driven, but also Dr. Bohacker and Dr. Stark. In addition to that, I also wrote a response to Dr. Bohacker, which is not in the record. So all of that, obviously I'm not going to comment on. Because it's my understanding that those reports are no longer before the court and don't require any response from me.
If we go then, was there anything else?
No,
If we go then,
Sorry, I
Mr.
have an
Schechter is up.
objection.
Yes, sir.
If my friend is now saying that they're not relying on anything from Bohacker and in response to Bohacker and Smart or any of Bohacker and Stark, excuse me. Is it their intention to redact Dr. Von Gernit's reports at this stage? This is, I guess.
Is this a discussion that, did this happen at all in early stages when we learned of the Hurons no longer participating?
Well, we knew that the Stark and Bohacker reports were not going in,
Mhm.
but Ontario did not redact its Von Gernit reports at all.
Yes, so my question is, was there a discussion? Is there an issue that, was there an ask for redaction and
No, I didn't ask for a redaction,
Okay.
but if my friend is now saying that the parts of Dr. Von Gernit's report where he addresses Stark and Bohacker can be considered as if they were struck out, then my cross-examination doesn't have to deal with those areas. You see, understand the problem.
so
and what's your plan, Mr. Marcello? in that respect?
we, there's no jury, obviously, and so we thought that you would simply ignore anything about anything about those reports.
You should always point out those things that you want me to ignore.
Yeah. Well, we will.
Okay.
I mean, that's kind of what I'm trying to do right now with asking him where you're focusing here, what matters here, and what are you not addressing anymore? We didn't white it out or redact it because it's not a jury trial and because we didn't think it contained particularly sensitive information, different than perhaps other things which are being redacted.
Okay.
So that's why we did.
I'll tell you what I did when I reread it last week, and that is particularly with all the references, there's a whole section on references to how the Hurons were paid. I did presume that I should read the report as if that had been redacted out. But maybe I shouldn't have, or I read it as if that would not be an issue in this trial. Maybe I shouldn't have. I was presuming that. And with respect to references to Bohacker and Stark, I also presumed it was not necessary for this witness to comment on them. And is that the same as what you're asking and maybe I've gone too far with respect to how payments were made, but is that the same as what you were presuming, Mr. Schachter? And you're asking Mr. Marcello to
It was
confirm?
really just, sorry, my initial question or comment was with respect to Bohacker and Smart.
Starks.
Bohacker and Stark, I apologize. It was not with respect to other narrative about RHT monies, which I thought that as I read the reports, there may be, in order to tell the story, you can't simply, I don't think you can just stick with RST.
Right, but they're not, okay, that's a,
Right,
Good
so
way to put it.
it provides context, what happened in RHT. But the Bohacker and Stark reports are the comments in them are very specific. And if my friend is saying we can treat it as though they were retracted, even though they're not in the report that's before the court, that is fine, and that obviates my problem of how to deal with it in cross.
all right.
Like we,
I think the question is one of reliance.
yeah,
Mr.
the intention, I mean, the intention was to focus on matters arising from Dr. Driven's evidence. That's the intention, really, at this point. Efforts to make treaty payments at large are in our submission important. They will be addressed through this witness, but it's not our intention to address overall Crown efforts to make treaty payments through reference to Stark or Boaker. We're trying to just focus this witness on the perspectives issues as they relate now to Dr. Driven's evidence.
Okay.
Is that
and
fair? Oh, I'm sorry.
well, I note the way that the question has been framed from Mr. Schachter, and it is, should the report be considered as having those references redacted?
Why don't, since we're going to break anyway, why don't we do that now, and we can just kind of air this.
Have a
out.
chat.
Yeah,
All right.
air it out, because I don't think it's got legs.
Okay. What time is it? 12:15, are you suggesting we break now?
I
Yeah,
am, because it might be
all right.
most efficient, if that's all right.
Very good. So we'll break now. The tech people are coming in to do some work starting at 12:30. And so wherever you need space, there's lots of it available. I don't know if their presence will bother you in here, if this is where you stay. How much time do you need for, should we reconvene at 2?
I think this is a very short conversation
Okay,
amongst ourselves in terms of the quotes redaction issue. I think it's very short.
okay,
So,
2 would be good.
okay.
or we could come back at 2.
Oh, you thought we should take now and come back before 12:30?
Well, we could if you want to, but you've got the people.
just
coming-
misunderstood.
The people are coming in, right?
Yes.
So maybe we could just shut it down. So.
All right, let's do
2.
that. Thank you. We'll come back at 2.
All
Thank
right.
you.
For recess until 2 p.m.